All righty. Looks like everyone has trickled in, and if someone comes in a little bit after this, we'll just get them caught up. So, happy Thursday. First, I do want to say congratulations to all of the fellows who are returning back to us from their trip to the desert of the bar exam. Y'all put in a lot of work this summer. I remember what it was like studying for that while doing a fellowship. So congratulations on that. It is a big accomplishment. And I just want to make sure that I acknowledge that and that y'all also acknowledge all the work you put in, because it's not an easy thing that we ask new graduates to do every summer, but you've made it through to August. And so please take a little bit of a victory lap after all that hard work you've done. I mean, it's hard to believe it's August already. We're coming close to the end of our time together. But before we do so, here are a few announcements that are going to be relevant to the last bit of your summer. So next week is the final summer seminar. On Tuesday, the 8th, we will be having a session on incorporating pro bono into your career, where we'll have a panel of 3 attorneys who in private practice and talk about how they balance their busy career and busy schedules with pro bono and other opportunities to give them a well-rounded approach to their career. So stay tuned for an email with the link to the page and the registration link and all of that fun information. Also next week is the alumni reception. We've sent out a lot of information about that before. Thank you to all who have registered already. If you haven't, please just let me know, reach out, send me an email, and we can go ahead and work on that and make sure that we can get you in, because without an RSVP, we got to make sure we have enough food for everyone to go around. So please, if you still are interested in going, hadn't signed up yet, just reach out and let me know, and we can work on that. Finally, I'll be sending around the second service tracking form for the interns and the first one for the fellows next week. So this is just like we spoke about before, to record your time and all the things you have done this summer, so that way we can keep track of that and all the great work that you've done. There'll be more details in that email, so don't worry about if you have questions now, but once we send it out, see if you have any further questions, and we'll make sure to work on that together. So again, that way we can capture all the great work you've done. So now that we've covered all of that, let's get to today's hot topics in legal aid session. Today, you will hear from 2 attorneys working on important issues here in Illinois. First, we will hear from Kevin Fee, who will be talking to you about First Amendment and constitutional issues here at the local government level. So Kevin is a senior special litigation counsel at the ACLU of Illinois, where he handles constitutional litigation and advocacy in a wide variety of topic areas, from First Amendment to LGBTQ issues to the civil rights of incarcerated people. Prior to working at the ACLU, Kevin was a litigation partner at Sidley Austin LLP, where he handled complex criminal and civil litigation in federal and state courts. While at Sidley, Kevin served as trial counsel for the Illinois Judicial Inquiry Board and chair of the Chicago office's pro bono committee. Kevin also serves on Philly's board of directors and was a longtime board member at Chicago Volunteer Legal Services. Then we will hear from Ruth Wallstra, who will be talking to you about the SAFE-T Act and the end of cash bail here in Illinois. And so Ruth is currently a deputy chief DuPage County Public in the DuPage County Public Defender's Office. Well, I'll say that 5 times fast. Having been employed there for over 22 years. Throughout her career in the Public Defender's Office, she has been assigned to the misdemeanor division, was supervisor of the juvenile division, and for the past 16.5 years has been assigned to the felony division. She is a member of the DuPage County Bar Association, DuPage Association of Women Lawyers, the DuPage County Criminal Defense Lawyers Association, and the 18th Judicial Circuit Pro Bono Committee. Now with that, let's go ahead and hear from Kevin.
Thanks so much, Artie, and hello to everybody. Thanks so much for joining. Congrats to those who just passed the bar. Gosh, the summer really has gotten away from me when I didn't even realize that was over. I much prefer talking to people after the bar rather than before, because I feel like when I talk to them before, I have to disclose that actually, yeah, studying for the bar is about as bad as you've ever heard and imagined. And it's just something you sort of have to get through. But now that it's all over, we can speak candidly about how miserable it can be. And congrats to everybody for getting through that. And congrats also for being involved with such a great organization in Pili. Have really cherished my time here, and I know that it's kind of the best way to build a pipeline to the public interest community, whether it's in a full-time capacity or a pro bono capacity. Hope you'll all stay involved as you launch your careers here in Chicago. So I am, as already said, Kevin Fee. I'm a lawyer at the ACLU. And what I wanted to talk about today is a topic that I think sometimes gets overlooked in discussions about civil rights and civil liberties. I think when it comes to talking about civil rights and civil liberties, everybody, or at least reasonably informed people, are rightly focused on what's going on at the Supreme Court level and in the federal courts, and then of course in national electoral politics and state electoral politics, all of which is of course very important. But what receives less attention, but I think is in some cases even more impactful for people's day-to-day lives, is the local government level. And really local government officials are on the front lines kind of day to day, weighing the most important and sort of weighty civil rights and civil liberties issues that exist. And the last year or so has been really hot area in the sort of local civil rights, civil liberties challenge and enforcement world. And we at the ACLU have been involved in a lot of cases at kind of the local level. And, in particular, it's become an especially hot area because there's sort of a new and very organized and very, I think, localized movement to advocate for policing of certain ideas and topics, in particular relating to LGBTQ issues and race at the local level. And sort of, the ACLU has spent a lot of time counseling public bodies and officials on how to respond to this kind of this movement, including through an open letter that we recently published to public officials, occasionally through direct involvement, negotiation with public officials, even litigation sometimes, and threats of litigation. And so what we're seeing, just to kind of drill down a little bit, at least in Illinois, is when it comes to First Amendment violations at the local level, is a little different from what you might expect. I mean, we're not seeing a lot of outright bans on books and events because government officials themselves disagree with their content. It's not sort of a full Footloose situation, dating myself with that reference, but it's at least not usually. What we're usually dealing with is actually a little different. It's sort of, we're seeing bans or attempted bans on particular content that are just as problematic, but they're really sort of reactions to the reactions. They're, rather than public officials themselves objecting to the content of a book or an event, they are instead being met with very, very loud opposition and acting in a reactive way, canceling events effectively to kind of just run away from controversy, and in a sort of misguided attempt to keep the peace in their community, which is totally understandable, but no less a First Amendment violation than an outright content ban based on personal preference, right? So, and I think it's important to, this sort of comes because the opposition, the sort of organized opposition that I've been talking about, often comes in the form of very loud, kind of monopolization of the public comment period during local meetings. So this is, think the parade of very vitriolic 3-minute speeches that you sometimes see outtakes of on YouTube or Twitter, where people show up to some public body meeting and get up and give sort of table pounding speeches in opposition to some local policy or ordinance or other. And it's important to think about who the public officials are that we're talking about here, right? I mean, these are folks who are usually, they have day jobs, right? They are used to kind of meeting once a week to talk about budget line items. And then all of a sudden, when they're dealing with 20 people sort of screaming at them that they're endangering children or doing some sort of terrible thing, they're not used to that level of heat, right? And so that sometimes, in our experience anyway, will lead to kind of very reactive decision making. And sometimes local officials are not even really aware, at least at first blush, that they're even dealing with a constitutional issue, in particular First Amendment issue. They just kind of want to make the screaming go away, and so they'll make reactive decisions that are sometimes ill-considered, and that's where we've unfortunately sometimes had to get involved. And so, this is all very general. So I wanted to spend some time today talking about a few specific examples of, ACLU cases from the last year or so that kind of fall into this local anti-First Amendment sort of agitation category that I'm describing here. So the first example is in Plainfield, Illinois. So Plainfield is a southwest suburb for those who are not familiar with Illinois geography. It's sort of a relatively far flung suburb, kind of exurb. They have a fledgling Pride organization called Plainfield Pride that was just formed over the last couple of years to advocate for LGBTQ issues and inclusion. And they wanted to host their first ever community Pride Fest last summer. And they applied to the local Park District Board for approval of the Pride Fest because it was going to be on Park District property. And they got approval, and there was really no fanfare whatsoever about the Pride Fest, which was going to include all sorts of sort of inclusive entertainment and vendors and all sorts of kind of family-friendly stuff. And one of the things that it was going to include from the very beginning was drag performances. Now, if you follow the news over the last year or two, you may be aware that there's been considerable political controversy that's arisen around drag performances. And this was a case where even after, a few months after this had been approved at the local level, sort of an organized group got a hold of this issue, started agitating on social media, rallying folks to come to a public meeting and advocate for the cancellation of this drag performance at the Plainfield Pride Fest. So about 20 people that this group put together showed up to a public meeting. They used the public comment period to sort of surprise, ambush, use your preferred verb here, the public officials who were expecting sort of a run-of-the-mill meeting and got anything but. There was some really nasty rhetoric, accusations about the board members, accusations about the folks at Plainfield Pride, calling them all sorts of horrible names, all surrounding this drag event. And by the way, the drag event was completely non-sexual, not like very innocuous, no scantily clad people or anything. It was just basically a drag queen that was going to be singing some songs and reading some storybooks. So at this meeting, once we got to in sort of like hour two of these very, very vitriolic public comments, the folks on the board started to backtrack a little bit and suggest publicly that they're going to consider canceling this event. And sure enough, after the event, they put on the agenda for their next meeting reconsideration of this long-standing permit to allow for this kind of entertainment in reaction to this controversy. Now, so the problem is, of course, that's a clear First Amendment violation. And you've got all of your elements you've just studied for the bar. I mean, right? You've got public officials threatening to restrict First Amendment protected expression in the form of, entertainment speech because of objection to its content. And the fact that the board members may not have objected to its comment really doesn't make any difference. If you are if you're restricting content based on anticipated audience reaction or community reaction, that is no less a, impermissible content restriction than a more traditional content restriction at the behest of the government official. So we got involved in negotiations with the board. We wrote letters. We ended up having to appear at another very vitriolic meeting, and ultimately threaten potential suit. Ultimately, the situation resolved itself. The public officials did the right thing and allowed the event to go forward. It was super successful. It was very well attended. They're planning another one for next year. But this was just sort of a good example of an instance where I think, public officials did not initially grasp the constitutional gravity of the decision that they were being presented with. They just wanted to smooth things over in their community, which is understandable. Again, I mean, nobody wants people to be at each other's throats at public meetings or otherwise in their local communities that are usually pretty quiet and friendly. But the First Amendment is the First Amendment, and you can't have government officials restricting speech based on content. So another example that's a little more extreme, unfortunately, is what happened in Lake in the Hills at Uprising Bakery. I'm not sure, some of these have gotten some press, so that you may be familiar with some of them, but this is a case where a local bakery called Uprising in Lake in the Hills had been hosting sort of entertainment events that, with the full blessing of local government, for a long time. They started to host drag brunches. So you're starting to see a theme develop here. And similarly, a different, although similarly themed kind of activist organization got hold of this issue and started to organize people on social media to protest this business for hosting these events. And that led to a quite nasty and escalating harassment campaign that started with fake Yelp reviews, from people who objected to the inclusion of the drag programming at the bakery, then escalated to nasty voicemails and emails, death threats against the owner, including at her house. Then people sort of showing up to the bakery and screaming at her. One person showed up and spit on the baked goods so that nobody could eat them. The police had to get involved. It was really, really ugly. And it eventually, the night before the first drag performance, culminated in a guy driving all the way from Alsip to Lake in the Hills, which, if you know anything about Chicago area geography, is a long drive. It's like 60 miles, to smash the windows of the bakery, break in, spray paint anti-gay slurs all over the walls, basically just tear the place up. And he was thankfully arrested very soon after this act of vandalism and charged with a hate crime. But at that point, what should have been sort of a community coming together moment turned into a kind of a further controversy, because the local government approached the owner of Uprising Bakery and basically told her, look, we can't afford to keep protecting you from these extremists, so you need to stop having the drag events. And by the way, you're in violation of all these sort of zoning ordinances. They professed to identify a bunch of zoning ordinance, although it was clearly, in our view, pretextual, that they just wanted these things to stop because they wanted the controversy to go away. And so again, we had this situation where local officials really clearly did not weigh the gravity of this situation, because it was a local matter, and people aren't used to thinking about the Constitution in that way. We got involved here, negotiated a sort of a resolution of this issue at the local level that allowed these events to go forward. It was a kind of a happy ending. The people in the community who were in support of the bakery and of sort of LGBTQ inclusion came out in really full force and made these events super celebratory and joyful and really successful. And so it was another instance where it sort of worked out well. But it started pretty ugly. So I'll give you one more. Well, you may have heard about the Downers Grove Library situation, where this was a really extreme case where they did have to cancel a drag event at the Downers Grove Public Library because there were credible threats of violence from folks, including somebody who sent the public officials bullets in the mail and threatened to kill them if they held this drag event. Now, this was not a case where we were involved, and it's a little bit of a different flavor because of the sort of personal threat law enforcement aspect of it. But this is sort of along the same lines. Another case that you may have heard of was in Aurora Pride. This was a little bit different, but another example of sort of local level First Amendment litigation. So Aurora Pride has a parade every year that's organized by a group called Aurora Pride. It's been a very successful parade. Aurora is actually the second biggest city in Illinois. I did not know that before this case, even though I grew up pretty close to Aurora. And so it's, a city that had sort of felt like it was long overdue for it to have a pride parade, and it had one in 2018 and 2019, and it was going to have sort of a big comeback in 2022. And unfortunately, the organizers of the parade got into a bit of a spat with the Aurora PD because of their request that police officers who were going to march in the parade do so in plain clothes rather than in uniform. Okay, so the police took offense at that. They felt that was disrespectful. And then the police who were going to work the parade as opposed to marching in it withdrew from their posts in solidarity with those officers and in protest of this request. So whatever you might think about the organizers' request to the police, it is undoubtedly it's First Amendment protected message. It is First Amendment protected speech. And so what you had here was a potential First Amendment issue that came to fruition when the city, in fact, canceled the permit for the parade after the mayor came out and withdrew the city's support very publicly and kind of further fanned the flames of this controversy. The city revoked the permit, and it revoked the permit on the basis of a sort of backwards provision in its special events ordinance that says that when you have a special event in the city of Aurora, it's the organizers rather than the city that are responsible for arranging for police protection. Which you may ask yourself, how could an organizer of a parade put together a police force? Good question. They can't. But the way that the ordinance was worded, it was their burden to do it. And so when the police officers voluntarily withdrew, it was alleged that the organizers had violated the ordinance by not getting the police to show up. So we got involved. We represented Aurora Pride. We threatened suit back in 2022, and they were able to hold the parade, thankfully, even though all this kind of blew up in the week before the parade was supposed to happen. The parade went forward, but only because the city decided to entice the officers to come back by paying them triple time and then passing that charge along to the organizers, who's just like, the organizers are like a 3-person nonprofit, people with day jobs who certainly don't have the money to be paying triple salaries for anybody. So they were hit with this huge bill and the prospect of facing the same issue with the same ordinance in 2023. We ended up having to actually bring suit in federal court. In this case, we filed a preliminary injunction in the Northern District of Illinois, seeking an injunction against the implementation of the ordinance as it stood, as being a violation of the First Amendment. We won that PI. We got a PI in May that allowed the 2023 Pride Parade to go forward in June. Thankfully, that case is still pending, so there's only so much I can say about it. But again, it's sort of an example of local, in our view, sort of confusion about where the First Amendment, begins and sort of normal functioning of local government ends. So, all of this is just, these are all obviously unfortunate incidents of real or threatened, constitutional violations that had happy endings. Obviously, though, the concerning thing is that this is undoubtedly happening under the radar as well, in cases where the ACLU or other lawyers don't get involved, or community members who might be, supportive of the First Amendment are not being alerted, and things are happening, without, like, outside of public view. I mean, we have heard sort of stories and rumors of kind of soft book bans in public libraries where, local officials are getting very quiet and informal requests from parents to take books off the shelves, and they're doing it without any announcement that they're doing that. You've got a lot of self-censorship by librarians and teachers. And so it's a real concern, and so one of the things, in addition to this direct advocacy that we've been trying to do at the ACLU, is really educate people who are supportive of a robust sort of public debate in their communities. Let them know that, that there are tools at their disposal. They can show up at these meetings too. They should know about the First Amendment implications of these things, because it's really most effective, I think, in our experience, when members of the community show up to these public spaces and advocate for inclusion of messages and advocate against censorship. I mean, that's who these public officials really want to hear from, is the community. And I will say that the sort of one part of the happy ending of most of these cases is that at these public meetings that often start out very, very kind of ugly and one-sided, as these cases develop, more and more people show up to the meetings, and you get a more and more robust and inclusive public debate, until you get to a point where, you have exactly what the First Amendment is designed to protect: a full discussion of important issues in the literal public square, that's inclusive of all viewpoints. And when that happens, truth and justice tends to prevail. Not to be corny, but that's what the First Amendment is really all about: is ensuring real debate, real exchange of ideas, and not sort of quiet attempts to torpedo controversial messages, which is unfortunately what we've seen way too much of over the past year. So that's just a little window into kind of one of the things that we've been working on here at the ACLU that I think sometimes gets overlooked. I'm happy to, I don't know if we have time for questions, but I'm happy to answer any now or later if folks want to contact me.
Yeah, we can see if there's any pressing, but I think what we can do is we could just have questions at the end of Ruth's presentation, and then that way we'll just have time for everyone to think of any and sort of pepper us all with them, because this is a very fascinating topic. It's an emerging issue, and it's one of those ones that, yeah, even I was like kind of surprised as I started to see it become more organized. You think it's just a bunch of rogue groups, but then you start to see there's a through line with them all. And so it is something that we all should be aware of, because when we see it happen in our communities, we can organize together and at least offer a counter perspective. Thanks, Kevin. And so I'm going to now kick it over to Ruth, and go ahead and let's see if we can get that PowerPoint to come up. And if not, we'll troubleshoot it together, because that's what we all do together.
Let's see. Are you able to see it or no?
No. Let me see.
Sorry, I'm just trying to figure it out.
Let me just make sure I've enabled that. Okay.
What did I do? Fortunately, I cannot figure it out.
If you want to just email it to me real quick, I can go ahead and share it as you go.
Okay.
That shouldn't be an issue at all.
Perfect. Okay, I just sent it.
Alrighty.
Okay, well, I will start, but that's okay. So as already said, my name is Ruth Wallstra. I'm a deputy chief here at the DuPage County Public Defender's Office. And one of my responsibilities is arranging and making sure we have coverage for bond court. So when individuals are arrested currently, officers, if they're a misdemeanor, they generally have the discretion about whether or not to file a misdemeanor charge. But for felonies, they have to go through the state attorney's office here in DuPage County to get screening approval. So we have to staff our bond court. It's 365 days a year, weekdays, weekends, holidays, everything. So I'm in charge of making sure that our attorneys are always covering that. So when the Pretrial Safety Act came into being, obviously this now plays a significant role in what we are trying to do in the Public Defender's Office for our clients and for individuals who are not yet our clients, but we anticipate will be. So just by way of background, Illinois has a long history of performing reform and making reform efforts. In fact, dissatisfaction long ago with the commercial money bail bond system actually allowed Illinois to be one of the first states to abolish bail bondsmen back in 1963. So Illinois has always tried to be on the leading edge and in the forefront of the other states in order to address pretrial issues. Now, over the years, New Jersey, California, and New York have limited bails, but only Illinois now is the first state to actually completely abolish and eliminate cash bail. So there's 4 policy reasonings behind bail reform. The first one is to end a system that disproportionately hurts the poor but favors the wealthier defendants. Obviously, if a bond is set at $10,000, 10%, the more wealthy individual will be able to post $1,000 plus the processing fee. And our clients who have not been employed or have no savings will not be able to post that, and they would end up in custody compared to an individual that is wealthier and would be able to post that amount. The second reasoning is to end systemic racism, since incarceration has been shown to disproportionately affect the African Americans and Latino defendants. The third reason is to basically increase accountability for the measures of police officers, with an example of requiring all police departments statewide to have body-worn cameras. And the last one is to actually improve public safety, because you're allowing individuals to then return to their communities, return to their families, to their jobs, to employment, and that would make more stable communities and make them safer because the individuals are back helping their families and friends. Now, in the recent years, the Illinois Supreme Court has taken steps in order to support pretrial reform in our state. In fact, they adopted a policy statement back in April 2017 that created the Supreme Court Commission on Pretrial Practices that was intended to provide a comprehensive review of the state's entire pretrial detention system and make recommendations on potential reforms. So they would do that using best practices by seeing other locations around the county. They consulted pretrial reform experts. They listened to stakeholders at public hearings throughout the state, and they analyzed myriad different sources. Yes, this screen right here, thank you. They analyzed numerous different sources on pretrial issues. They had a thorough study. They had a spirited debate and discussions in public forums, and it ultimately issued a report in April 2020 that listed more than 50 recommendations that included recommendations so that defendants are not denied liberty solely because they're unable to financially secure their release from custody. And they observed that the General Assembly actually bore the responsibility to amend the criminal code to align with its recommendations. So this commission basically was saying the legislature should do this. And it urged the legislature to ensure that the conditions of release would be non-monetary, least restrictive, and considerate of the financial ability of the accused. May I have the next screen, please? Thanks. So what ended up happening based on that is in February 2021, the Public Act, or what we refer to in the Safety Act or the Pretrial Fairness Act, actually was passed by the legislature and signed by Governor Pritzker in February 2021. There were then some rumblings and concerns about it, so it was later amended to address some of the concerns, and it was codified in that 725, the Illinois Criminal Code statute. May I have the next slide, please? Thanks. So the pretrial release provisions that I'm going to focus on, because there's a bunch of other things that don't actually relate to bond, but relate to police officers and various other things. But the one I'm going to focus on today is basically centering on the abolition of monetary bond. So instead of that, they established a default rule that was indicating that all persons charged with an offense shall be eligible for pretrial release on a personal recognizance, which basically is their signature without posting any money, subject to conditions of release that the trial court deems appropriate. And some conditions would be such as electronic monitoring or home supervision. So under this new scheme, all defendants were presumed to be eligible for pretrial release. And it was the state's burden of establishing that an individual is eligible for detention. So that requires that they actually have to file a petition to detain. And if there's no detention petition filed, the individual has to be released. So no petition with when a person's arrested, they have to be released. So there is a mechanism with this detention that then triggers some factors that the court has to consider. So the court can detain an individual for two different reasons. The first one is that it's a enumerated a felony, plus it, quote, poses a real and present threat to the safety of any person or persons or the community. The other way an individual can be detained is that there is an enumerated offense other than a class 4 felony offense, and the court has to conclude that there is, quote, a high likelihood of willful flight to avoid prosecution. So that means all references to the term bail or the court's discretion in the determining the amount of monetary bail were removed and instead replaced with this factor system that the court has to now consider and conditions that the court can then impose. Now, some of the factors still include what we consider now, the nature and circumstances of the offense. So if it's a violent offense, family community ties, history of drug and alcohol use, criminal history, and failures to appear in court. So things that people were concerned about, like they're releasing everybody and nothing's being considered, isn't true. So a majority of actually what we're doing now and what's considered would still be considered in the future. May I have the next slide, please? So this chart basically is just a simplified version of how we anticipate the act would be. So you would be arrested by law enforcement. You're either released on a citation or you can be released with a summons. So you're not taken into custody. And the third approach is you go for your initial appearance hearing. At the initial appearance hearing, the state could file a petition if the statutory factors are applicable. If they don't, then the client is released. If there is a petition for detention, it then goes to the next step, which is the detention hearing, for the judge to determine if the individual should be detained or not. So either then the defendant is released or the defendant is held in custody for no bail. And that, of course, would affect, again, the violent criminals, the consideration of your criminal history, the nature and circumstances of the offense, your failures to appear history, the threat that you might pose to that individual or individual's family who's the alleged victim in the community. May you go to the next slide, please? Thank you. So another major feature of the Pretrial Fairness Act is relying on summonses rather than warrants to ensure that defendants appear in court whenever possible. So right now, if a person doesn't appear in court, typically the judge issues a warrant and puts a bond amount or a no bond. So what they are instead going to be doing, instead of automatically issuing a warrant, the goal is instead to issue the summons for a future court date for the client to appear. And if they do not appear at that time, they issue a warrant, and they would then serve the individual with a summons. And if the individual doesn't appear in court within 48 hours, then the warrant would again issue. So they're trying to give individuals an opportunity to show up in court for unforeseen circumstances that they're just not able to relay if they don't have an attorney or somehow get it across to the court of why they're unable to appear in court. So these new provisions, we know were obviously supposed to take effect in January 1st of this year, but constitutional challenges were filed in September of 2022, initially by Kankakee County, and then they were joined by various other state's attorneys and sheriffs in other counties throughout the state. So all those various lawsuits were combined into one lawsuit. Will you put the next slide, please? So ultimately, as we know, July 18th of this year, the Illinois Supreme Court ultimately upheld the Safety Act in the Roe versus Raoul case. And just briefly, just to go over the 8 counts that were alleged in the lawsuit. May you push the next, thank you. So the first count was basically, the allegation was that the legislature was trying to amend the Constitution without bringing it to the people for the general vote. So the trial court agreed and said it should have been a ballot decision on a general election. Now the Supreme Court rejected that and said statutes have a strong presumption of constitutionality because the legislature is principally responsible for determining public policy. So it is their responsibility to do that. Plus the second reason was the burden of challenging the statute is that there's no imaginable set of circumstances under which the statute would be valid. And the Supreme Court decided that there was. May you do the next slide? So count 2 alleged the legislature's failure to comply with the single subject rule, basically saying that there were multiple bills confined in this overall bill as opposed to one subject per bill. And actually the trial court rejected that argument, so it never made its way to the Supreme Court. May you have the next slide? So count 3 is the allegation that it violated the bail clause of the Illinois Constitution, and the trial court agreed, stating that this law appeared to have a much broader purpose than simply conferring rights on defendants. And the Attorney General and the various defendants in the case didn't explain why the courts no longer had authority to ever consider monetary bonds as a condition of pretrial release. So basically stating that bail has been a centuries-long approach in this country, and based on the new law, persons are no longer bailable with sufficient sureties was the term that was previously used, because sufficient sureties for the trial court, they believed included monetary bail. May you do the next slide, please? So the Supreme Court rejected that and said the plain language of the Constitution, the term monetary is actually never actually included. And the trial court incorrectly believed that monetary bail is the only way to assure a defendant's presence and to protect the public when there are other multiple ways. Because it does actually consider and has exceptions to keep the most serious and potentially dangerous offenders in custody after hearing to determine if there's a real and present threat, and also considering the nature and seriousness of the offenses. So then they determined that the trial court misunderstood or misapprehended what the drafters of the original bail clause did. Count 4 is regarding the Crime Victims' Rights Bill. So the trial court agreed and opined that eliminating all monetary bail in all situations does affect the constitutionally mandated safety of protecting the victims and their families. But the Supreme Court said, actually, the plain language of the Constitution doesn't say that. The Act actually expressly does take into effect the crime victims and their protections, because it has the factor of considering the real and present threat to the safety of victims and their families. And the last one is actually the Crime Victims' Rights Clause is part of the original Bill of Rights, so it is incorporated in there. The fifth one is the violation of the Separation of Powers Clause. So the trial court agreed and said bail is administratively only for the courts, and the legislature encroached on the judicial's authority. It stripped all the courts of the authority to ever consider monetary bail and impermissibly impeded in their inherent authority to detain individuals. Now, the Supreme Court rejected that and opined that the legislature, since basically 1818, has long regulated the bail system, and so they disagreed in that situation. Now, counts 6, 7, and 8, basically the trial court all rejected their arguments, and so that was never decided in the Supreme Court. There was a separate and concurring opinion by Justice O'Brien. Basically, just you want to highlight regarding the plaintiff's lack of standing, which he thought the majority glossed over. Basically stating, you only have standing if the individual has suffered an injury or is in immediate risk of facing injury, not because it's a pressing, unusual circumstance that affects public interest. And there was also a dissent that was written and joined, basically outlining 6 different things of why they dissented. Basically saying it should have been declared invalid and unenforceable, no matter how beneficial it is, because it does directly violate the Crime Victims' Bill of Rights. They did believe the plaintiffs have standing, and it basically maintained that the court has a duty and a discretion to reference and use monetary bail. And they did believe that the drafter's plain language did actually say about having and denying and fixing a specific amount of bail and setting conditions of bail. So they believed, based on their interpretation, overall that it should have been upheld. Now, more to the implementation challenges. So I believe there's actually 6 basic implementation challenges throughout the Illinois. And then in a minute, I'll just talk about DuPage and specifically what I'm involved in. So funding. What about the county's inability to pay for the Pretrial Fairness Act regarding personnel? We're fortunate, our county board is very generous, and so like we can just shuffle things around. But counties downstate, how are they going to have the funding based on their county board or taxes or however, in order to be able to pay for probation, extra state attorneys, extra public defenders, because now it's the public defender mandate. We have to get appointed to every individual in bond court. So just funding. And then logistics of it. How do you do training? What about actually making the court orders, which I know the Supreme Court is going to be, they have some draft proposals, and so it will be uniform. But I mean, actually just physical space for this new court proceeding. There has to be a new location for it. And what about personnel, reassigning individuals, hiring replacements? There's also the safety for pretrial monitoring officers. They're going to have more individuals on bond. And so, you know, in the past that they might have gone to pretrial officers to visit somebody, they might have to divide themselves. And so there's more driving. They might get into accidents. They might encounter a dangerous situation when they're meeting somebody. There's just a variety of safety considerations also. Number 5, the lack of mental health and substance abuse placements. Right now, a lot of individuals that are in custody can't post bond, but they have mental health and substance abuse issues. So individuals think, you know, keeping in jail for their protection. So if we're releasing these individuals, there's normally a wait list to begin with for substance abuse and mental health treatment placements. So where are these individuals going to go? And then the 6th one, is there going to be an increase or is there going to be a decrease in the amount of orders of protection? Are more domestic battery cases or similar offenses going to be held in custody, or are they going to be released? And so more petitioners will be coming for an order of protection. So I think the Illinois Supreme Court, in anticipation of all counties not being equal funding-wise and ability-wise, they established the Illinois Supreme Court commission to assist with the implementation of the Pretrial Fairness Act. It's called the Office of the Statewide Pretrial Services. So it's going to be in every county, and there's different districts and regions. But their vision is to promote pretrial justice and community safety. And their mission is then also to assist in the administration of justice, as well as to promote community safety by ensuring fairness and equality in the pretrial process everywhere equally throughout the state. And they have core values about community safety, equal justice, equity, integrity, respect, diversity, inclusion, and collaboration. And this next slide, basically, these are the divisions of how the Illinois Supreme Court has divided up how their office will assist the different regions that we have. And then the last slide, practical applications for DuPage for me. Again, logistics. We do fortunately have extra attorneys, so we're moving attorneys around. We have been able to modify our jail. We actually have a courtroom in the jail, and we have been able to modify that courtroom so that we have the individuals there that have been arrested. We have a judge whose chambers is actually in that jail courtroom. We've been able to modify and have jail accommodations. We have to have a lot more information. Probation has to meet with these individuals to prepare a pretrial report. So we've been able to reconfigure how we do it. So we have 3 different jail chutes with microphones, and we'll just use our cell phones for language other than one that we speak. And we're also working on doing training, not just for our attorneys, but for the state attorneys and for the judges. We're going to be developing cheat sheets. Like here is a chart of everything that's non-detainable. These are the factors that can be considered. These are the conditions that you can apply, because some conditions only apply in certain circumstances. And then some individuals, if they're just going to be issued a summons by the police, they actually won't be fingerprinted, but the police wants them to be fingerprinted. So we're considering actually putting something on the 4th floor where our criminal courtrooms are located to be basically a fingerprinting station. So individuals, when they come for court, they have to physically appear in court. They can just go to the fingerprinting station and have that done. So that's kind of a thumbnail, really quick sketch of the Safety Act and the pretrial fairness. So I'm open to any questions, as I'm sure Kevin is as well.
Thanks, Ruth. Thanks, Kevin. So yeah, anyone has any curiosity, any follow-up questions or anything like that, please feel free to either put them in the chat and I can ask for you. Or if you just want to unmute and shout it out and be bold, that's also pretty cool. Well, if y'all don't, I do. So I will just take this opportunity to ask a few questions. So I'll start with you, Kevin. So are there any other cases, issues, or anything like that that the ACLU has been monitoring, maybe can see turning into more of a bigger issue going forward? Or just kind of what does the future landscape look like for these First Amendment challenges here in the state of Illinois?
Sure. Yeah. We have continued to see a lot of agitation around these areas, and it's expanded into areas beyond just the First Amendment. I think, for example, we had an issue in Danville, Illinois, where local governments, so the local government attempted to enact an ordinance that was called a sanctuary for the unborn ordinance. And they effectively attempted to overrule the Reproductive Health Act, which is a long established Illinois statute that protects women's reproductive health at the local level, and by sort of deputizing themselves under federal law to purport to enforce the Comstock Act against the mailing of medication abortion drugs. And so that was an issue where we got involved. It was, obviously, in our view, a clear overreach at the local level. We've also seen a lot of sort of local activity around transgender access to bathrooms, locker rooms, sports, in schools, and policies surrounding that. So this is an area that we're getting increasingly involved in, and especially sort of in communities outside of the Chicago area, where we sometimes have less strong and well-established contacts. and that tend to be more sort of rural in nature, and therefore the sort of what's happening there is not receive as much media coverage because there aren't large media outlets there. So these are all areas that we've been monitoring quite a bit. But I mean, I think that folks who unfortunately are invested in shutting down speech about these issues have come to the realization that they can do a lot at the local level, even when they sometimes may feel shut out at the state level or the national level. They realize that where most people's lives are shaped is in school boards and library boards and park district boards, and so they are very active in these spaces. So I think that that's just something that folks who are friends of civil liberties need to keep in mind and try to counteract.
Thank you. And Ruth, for you real quick, do you anticipate any pushback from the DuPage County community around bail reform? And does your office have any plans or trying to work together to get messaging out to folks about how this isn't the start of some, I don't know, lawless period, but it's actually a great reform for citizens in the state of Illinois?
We've actually been very fortunate. Our DuPage County State's Attorney did not join the lawsuit against the act and has actually been and was one of the original drafters of the legislation. So he had active participation. So he's been able throughout DuPage, and I think throughout the state, has been encouraging people to enact this law and follow it. And so we've had that friend, so to speak, on our side from day one. And so he's been very active, and we've been very fortunate to be able to work hand in hand with him in order to put this out there for our clients. So we've not had any pushback. Plus, our county board is also very much in support of it and has been very supportive in making announcements and, just putting it out there that this is the right thing to do for our clients, not just in DuPage, for other individuals that happen to come to DuPage and commit crimes here.
Thank you. And not seeing any more questions, we'll go ahead and wrap up now. Thank you so much, Kevin and Ruth, for taking the time to speak on these important emerging issues here in the state and local levels, because it's very easy to forget about these major issues happening, in the more local level, as national news tends to dominate a lot of the coverage. And it's easy to assume that because we as Illinois kind of vote blue and have more statewide policies that are supportive, that there's still things happening at the local level that we should keep our eye on and, lend a hand when we can. So with that, I'll give everyone a minute back because I'm so generous. And thank you so much for joining us, and I'll see you next week. Bye, everyone.
Thank you.
Thanks so much.
Yes, thank you. Bye.